right. Good morning, everyone, and welcome to the November 5th, 2021 Board of Administration meeting. I want to welcome first Rosie Anick. She is going to be taking over Cynthia's role, and obviously we wish Cynthia a happy retirement, and we're also going to have Melody Hazard helping us today as she's showing Rosie Anick the ropes. And so welcome, Rosie. We're very happy to have you here. And I think we wanted to also note that we're going to be joined by Lisa Marie Harris at about 9 a.m. But right now we're going to ask Melody to call the roll.
Okay, I'm happy to, Karina. Okay. Karina Coleman?
Here.
Brett Bartolotta?
Here.
Michelle Bush?
Here.
Natasha Kalura?
Here.
And we know Lisa Marie Harris will be in late. Charlie Hogquist?
Present.
Paul Kaufman?
Here.
Paul Lotz?
Here.
Lou Maggi?
Here.
Louis Nguyen?
Here.
Cliff Shearson?
Here.
And Bobby Spoon.
Here. Okay, great. And then I also just want to note that in this virtual environment, as we are voting on action items, a roll call will be carried out. And if you are going to make a motion, please state your name first. That just helps Rosie and Melody. The first thing I'm going to do is ask if there's any public comment.
We do not have any public comment today, Karina.
Okay, great. And we have a quorum. So we are going to be taking actually the business operations portion out of order on our agenda because we have first an action item here relating to a resolution to allow us to meet virtually today. And I'm going to hand that over to Greg.
Thanks, Greg. I can take this as it's my item.
Sorry.
No, thank you. And good morning, Karina. So as you know, we have been forced to meet virtually since the beginning of the pandemic in March 2020. And we've been able to do that safely with the public attending as well as the board members and staff. The law recently changed in September this year that requires us to pass a resolution in order to continue meeting the way we do from our private residences and whatnot. So the proposed resolution in front of you is to allow this meeting to go forward virtually as we are doing. It recognizes that California is still in a state of emergency because of the COVID-19 pandemic, that the risks to meeting in person continue, and that we will continue to allow the public to attend and participate in all of our meetings. So with that, Karina, I will need a first, a second, and a roll call vote to pass this resolution.
Charlie,
I will be happy to make a first motion on that. Is there a second?
All seconds.
I'm sorry, who was the second, please?
All seconds.
Thank you, Paul. Okay, we will take the roll.
I think we're going to call them. Okay.
Okay, Karina Coleman?
Yes.
Brett Bartolotta?
Yes.
Michelle Bush?
Yes.
Natasha Kalura? Natasha Kalura?
Yes.
Thank you. Charlie Hogquist?
Aye.
Paul Kaufman?
Yes.
Paul Lotz?
Yes.
Lou Maggi?
Yes.
Louis Nguyen?
Yes.
Cliff Shearson?
Yes.
And Bobby Spoon?
Yes.
And Lisa Marie is still out, is that correct? I don't want to skip her. Okay, all right. Motion passes 11-0.
Okay, great. Now I'm also going to recognize Johnny Tran again, and he has a training session. So I'll turn it over to John.
Thank you, Karina, and good morning, board members. Before you, just an information item, so no action is necessary. It's your annual review of your open meetings law. This is a law that's dear to my heart because I help keep you out of trouble and make sure that we do things according to the books. So if Farnaz would start the presentation, I would appreciate that. Please feel free to stop me when necessary. You can go to the next slide. So this is an overview of what we're going to talk about for the next 10 minutes. What is the Brown Act or Open Meetings Law Act? When does this act apply to you? What agendas, notices, and documents are necessary? What about public participation and attendance, especially in this virtual environment? And then the new law, California Assembly Bill 361 that passed this year. The next slide, please, Fernand. So the first sentence there is straight out of the Open Meetings Law, and I think it summarizes the intent of the act and what we do to follow that intent. And the law says the people do not yield their sovereignty to the bodies that serve them. The people insist on remaining informed to retain control over the legislative bodies they have created. SDCERS is a public entity. You and I are public servants. We serve our members and we serve the public in general. And so our business is really transparent. That's one of our core values and something we as staff strive to bring to our work every day. With that, SDCERS' standing committees, as well as this board meeting, every board meeting, are open to the public and governed by the Brown Act. So that means the public can attend these meetings, they can participate in these meetings, with just a few exceptions, which I'll explain a little later. Next slide, please. Okay, so when does the act apply? I stated the act does apply for our standing committees. It also applies for our full board meeting. Well, what about other times? Well, the law says anytime there is a meeting that qualifies under the Brown Act, and a meeting is any communication among a quorum on a topic within the jurisdiction of the board. So a quorum of a committee, a quorum of a board, when you're talking about something within the purview of SDCERS' business. Communication can be over text, phone, in person. It can just be seeking clarification, anything that we do business on. So private meetings, pre-meetings, retreats, study sessions are all meetings and therefore open to the public. Next slide. Thank you. So the question then is, when does the act not apply? When is it not a public meeting? Well, individual contact. One of the board members kindly asked me if they called another board member today on a topic, would that be a Brown Act violation? And the answer is no, because it's two members there, two board members, and that is not a quorum of a committee or the board. So that meeting was fine, and I do appreciate you checking with me on different questions. But it can't be a serial meeting. So what's that mean? That means we can't have one board member talk to another board member, talk to another board member, where it ends up being a quorum or behind the scenes meeting of enough votes to pass an item. Also, if a majority or quorum of the board members were to attend a conference or a community event or a social event, that's also not a meeting under the Brown Act, so long as we don't talk about SDCERS' business. And lastly, an ad hoc committee formed by our president would not be governed by the Brown Act or a public meeting, because an ad hoc committee can't be a quorum and it's a temporary body with a finite purpose. Next slide, please. Thank you. So if we have a meeting under the Brown Act, what are the requirements for that? Well, you've got agenda requirements, you've got notice requirements to the public, and then document requirements. So for a regular meeting, the law requires us to post the agenda 72 hours before our meeting. We do a better job than that. We have since before I got here, in that we post it the Friday before this Friday meeting, so a whole week in advance. The agenda must state the meeting time and place and contain a brief description of each item of business to be transacted or discussed at the meeting. Again, SDCERS goes beyond the law in that we just don't post a brief description. We provide the public documents along with the agenda title. That way the public can really see what we're suggesting, what the recommendations are, what the documents are that you're seeing. The board may not discuss or act on matters outside of the agenda. And lastly, staff reports and materials must be available to the public upon request, unless there's an exception. Next slide, please. Public participation. Our meetings are open to the public and must be compliant with the Americans with Disability Act. Open to the public includes public participation, people talking, honestly criticizing what we're doing. If you read the newspaper this week, there's been different county supervisor meetings that have had difficulty with public criticism. That's part of what we do as public servants, is hear criticism and recognize that and be part of the First Amendment right of our country. Next slide. I want to talk about AB 361 as my last slide, which passed September of this year. Before this law, the default for public meetings was that members of the public would meet in person with us and be able to participate in person. In March 2020, with the pandemic, it became very dangerous for everyone to meet in person. And so the governor signed executive orders that allowed us to meet virtually from the safety of our private residences and other locations. Those executive orders expired in September and were replaced with a statute, or this bill, AB 361, which allows us to continue meeting in private residences virtually, as long as we pass the resolution, which we just did about 5 minutes ago. We continue to have to post the agendas, invite the public to attend, and we do that by, if you look at our agenda, it shows how people can attend, people can speak and participate. The public must be given a reasonable amount of time to participate in real time, not just in writing, but in speaking to you so you can reply. If there is a broadcasting disruption, if the public can't hear us, we do need to stop business until we can fix that. I want to talk about what other systems are doing, what we want to do to transition back in person. You know, the hope, I know, of all of us would be to be able to meet in person again. Well, what is that going to look like? Well, right now, staff doesn't believe we're ready for that, even though some systems and other agencies have decided to meet in person. The city of San Diego has a very detailed plan for its city council to meet in person. Their plan talks about vaccination, security, checks, meeting with unions, quite a robust process. I see the process happening transitionally, going from completely virtual as we are now to something of a hybrid, perhaps board members who are comfortable meeting in person while the public meets virtually, and then eventually transitioning to meeting in person, God willing. Greg, I wanted to know if you wanted to speak on this and SDCERS' plans for transitioning.
Absolutely. And Johnny and I are definitely on the same page when it comes to honoring our transparency value in making sure our organization is transparent and that we facilitate the public reviewing what we're doing, how we're doing it, and when we're doing it. And I really appreciate the opportunity to talk about kind of our goal to return to the boardroom and making sure we do it thoughtfully and methodically so that we can keep everybody healthy and safe. And so we can probably talk about, opening up SDCERS back to in-person meeting in stages. And as Johnny mentioned, we're currently, I would say, in stage 1, where our current level is where all participants are remote, except for those staff that are required to run the board meetings. And what we're hoping to do, as Johnny mentioned, is go to stage 2. That's where board members and staff are able to attend in the boardroom. As Johnny mentioned, we would probably have the consultants and the public and perhaps some board members and some staff continue to join us remotely. And this is commonly referred to as a hybrid approach. And then stage 3 would be when all board members, staffs, and consultants and public can attend in person in our boardroom. It was kind of fun to think about. We have some new board members on board that have joined us since March 2020 and never seen our boardroom. But it is a wonderful place, and you will enjoy meeting there someday. As Johnny mentioned, our local public health official recently recommended that we continue to have public meetings to ensure, in a manner to ensure the health and safety of all participants. And that's why we continue to be in stage 1. And we're also kind of worried as a community about avoiding what they call the 5th wave of COVID and perhaps the dreaded, now termed dual-demic, which would be our just regular run-of-the-mill flu season combined with COVID. So we're still apprehensive as a community on what we should do in the future. With that said, I thought it would be a good idea in late December to reassess what the local health officials are saying, along with checking in with individual board members to see their health situations and if they're able to attend in person or if they still need to attend remote. So we'll be looking at that. And so hopefully in January, our community is healthier and we can actually have hybrid meetings where some board members and staff can attend in person. So that's kind of where we're looking into the future. But again, our goal is really to return to in-person meetings as soon as practically possible, but making sure we support our community by following local public health officials' recommendations, and so that we can hold open, transparent meetings in the safest manner possible. So in summary, depending on the status of the pandemic and the severity of the upcoming flu season, we really anticipate holding January either as a full virtual meeting, as we're doing today, or as a hybrid meeting where the boardroom is open to some board members and some staff. So that's kind of our look into the future. And Johnny, back to you.
Thank you, Greg. Next slide, please.
Greg, this is Michelle Wagner in the boardroom. I apologize for interrupting you guys. We are having technical difficulties with some of the audio that's streaming on the public site. We'd like to see if we could pause the meeting just to see if we can troubleshoot those issues and get us back online.
I think we would definitely want to do that. Yes, thank you. How long do you think you will need?
I'd like to give you a number, but at the moment, I can't tell you exactly. If we could just start with maybe 5-10 minutes, and I can give you an update. I can give you an update then.
Yeah.
Karina, do you mind if we have an impromptu coffee break?
We are going to have a break, and we'll shoot for 9 a.m. Thank you, everyone.
Thank you.
Okay. Thank you, everyone. Welcome back. We did have some audio technical difficulties, so thank you for your patience working through those. Johnny, I'm going to turn it back over to you to continue with the training session.
Thank you, Karina. I didn't have any more to discuss. I did want to take any questions and thank the board for continuing to follow the law. You know, SDCERS had litigation over the Brown Act prior to any of our time here. And my goal is to keep us out of that and to comply with the law so the public can participate and we can participate in these meetings safely. Any questions? Otherwise, thank you, Karina.
Okay, and just a clarification, Johnny. So for example, if 3 members were to meet, and let's say those 3 members were sitting members of the investment committee, then that would constitute an investment committee meeting because 3 is not sufficient to qualify as a quorum of the board. Just want to make sure I understand that.
Yeah, good question. So a quorum of the investment committee, there's 6 people on the committee, right?
Yeah.
So a quorum would be 4.
Okay.
So three could speak without being an official meeting of the investment committee. That's fine. It's when you get to that fourth that you have trouble.
Okay, thank you so much for that clarification. Great.
And Johnny, what is quorum
Josh?
for, sorry, what is quorum for the whole board? How many members?
Quorum for the whole board is 7.
7. Got it. Thank you.
So Louis, just to pick up on that, if for some reason 4 members of the investment committee found themselves at the same investment conference independent of SDCERS, do you does one have to walk away from the other 3 so that you don't violate the law? I mean, is that sufficient? I mean, we're colleagues, but we also don't want to violate the law, right?
Yeah, Cliff, good question. So you can all attend the conference or any other educational or social event. You just can't talk about SDCERS business.
Okay.
So we couldn't say something like, hey, let's talk about that investment manager for our portfolio. That would be something we would want to put on the agenda and talk about a public meeting.
Fine. So, but if we all find ourselves, let's say, at a Red Cross event, we can still stand around and chat. It's just we can't discuss business of SDCERS.
Absolutely. And I commend you for going to those nonprofit events. Thank you.
Okay, great. Thank you for that training, Johnny. The next thing we're going to review is the consent agenda item.
I'm sorry, Karina, I think Marcel had her hand up.
Oh, sorry. Thank you. Marcel, go ahead.
Hi, I just have a quick question for Johnny following up on your question, Karina. So Johnny, if 3 members of the investment committee were together and they did talk about some SDCERS business, which is fine because they're not a quorum, they couldn't talk to a 4th person about what they talked about, the 3 of them, because now they've turned it into a serial meeting?
That's correct.
Thank you. I just want to make sure I understood.
It's a good leading question. You'd make a great attorney. Thank you, Marcel.
Okay, well, that was a great Q&A session. Any other comments before we move on? And it's a little hard for me to see hands up in the virtual environment, so please forgive me if I do not recognize you immediately here.
It's also a clarifying question, Johnny. So if there was, for whatever reason, a standing meeting between 3 investment committee members who meet for coffee or they meet to run or whatever it is that considered? How does that view?
Well, you're getting into a little dangerous territory when you talk about a standing meeting. So if 3 members met consistently to talk about SDCERS business, we'd have to talk about whether or not that was appropriate. If the 3 of you met for coffee, again, that would be like an educational conference. You just want to avoid shop talk in general, especially if this is something that you do regularly. Thank you, Louis.
Thank you.
All right. So now we're going to move to the consent agenda items. And we have the service retirements, the drop entries, the drop retirements, and the training requested educational conferences. And I will need to have a motion and a second on consent items A through D.
Charlie moves to make the motion.
All seconds.
Okay.
All seconds.
Karina, it's Lou. Just a quick question. Was one of those consent items the drop crediting rate?
No, they're drop retirements, drop entries, drop retirements.
Got it. Sorry.
Okay. So it looks like we have a first by Charlie Hogquist and a second by Paul Kaufman. I heard Bobby get in there too. So next time, Bobby, I think we're ready to call the roll.
Okay. Karina Coleman?
Yes.
Brett Bartolotta?
Yes.
Michelle Bush?
Yes.
Natasha Kalura? Natasha Kalura?
Yeah.
Thank you. Lisa Marie Harris? Okay, not in yet. Charlie Hogquist?
Aye.
Paul Kaufman?
Yes.
Paul Lutz?
Yes.
Lou Maggi,
Yes.
Louis Nguyen,
Yes.
Cliff Shearson,
Yes.
Bobby Spoon.
Yes.
Okay, motion passes 11-0.
Okay, beautiful. Then the next item we have is the Disability Committee meeting highlights, and I'm going to turn that over for the report out by Charlie Hawkins.
Good morning. Hope everybody's okay. If you hear some noise in the background, I am surrounded in plastic. They are painting my townhome, so I can't go in or out. But yesterday's Disability Committee meeting was an interesting meeting. We had 4 action items. Item number 4 was pulled, further discussion today. And that item is pulled, but I do want to move forward and just discuss the 3 items that were approved on consent. Number 1, of course, was our agreeing to meet virtually, and the other 2 items was the staff's recommendation to approve a non-industrial retirement for Gustavo Cambados, and also the staff's recommendation to approve an industrial disability retirement for Kevin Seeley. Those 3 all passed unanimously and were moved to consent. But item number 4 was handled a little differently. It did not move to consent because we did not get a motion or a second. So at this time, I do want to check, is the attorney for our member present for comment today?
Yes, he is,
did make
Charlie.
comments yesterday. Excuse me?
Yes, he is.
Let us vote on those first 3 items, and then before we go to number 4 and discuss it, we'll let the attorney talk if that's appropriate.
Okay.
Okay. And I'll make the motion to approve items 1 through 3.
I'll second it. Natasha Colera.
No second is needed. Melody, could you call for the vote?
Yes. Karina Coleman,
Yes.
Brett Bartolotta,
Yes.
Michelle Bush,
Yes.
Natasha Kalura,
Yes.
Charlie Hogquist,
Aye.
Paul Kaufman,
Yes.
Paul Lotz,
Yes.
Lou Maggi, excuse me,
Yes.
Louis Nguyen,
Yes.
Cliff Shearson,
Yes.
Bobby Spoon,
Yes.
and I see that Lisa Marie has joined us, but I'm not certain if she heard the item.
No, I'll abstain. Thank you.
Okay. Okay. Motion passes. 11-0-1 recuse. Abstain. Sorry.
Okay, great. And welcome, Lisa. Just to orient you, we're on the Disability Committee review, and Charlie Hogquist is walking us through action item 4, which was pulled from the committee's agenda at the Disability Committee meeting.
Great, thank you.
Before we discuss any the issue, if the attorney for Mrs. Member Minton is present, we'll give him his 3 minutes to speak to us, and then we'll talk more about the issue.
Okay, Mr.
Can you all hear me?
Yes.
Yes, we can hear you.
All right, wonderful. Thank you for allowing me a few minutes here. I wanted to tell you a little bit about Miss Minton's injuries here. She had 2 industrial injuries. She had her first, 2 involving what we're talking about today. She had her first on December 15th, 2011, where her and her partner were rather badly beaten. She then went back to work and had another injury on May 26, 2012, where she stepped awkwardly off of a curb. She got about 2 months just a little over 2 months worth of treatment for that on her low back. She complained of pain to her lower right side of her back. On August 2nd, she was seen by the chiropractor, Rick Luce, who performed some tests on her. He did say that it appeared to be positive for a possible disc problem in the lower right side of her back. She was then seen by Dr. Ignacio the very next day on August 3rd and was pronounced permanent and stationary. Part of what she was told was to do exercise, yoga, stretching, etc. at home, which for her back health, she continued to do that very diligently as a form of treatment. She continued working in patrol until approximately 2015, where she then changed roles somewhat. She still worked as an officer, but she moved into the wellness unit, which provided her the ability to not have to wear the duty belt, among other things. In 2017, she was at home, was getting up off of the couch and felt significant pain in her back. She fell to the ground and was there for some time. She saw doctors that she had seen through workers' comp. They all said at that time they believed it was due to her earlier work injuries in 2012. She got treatment, including an MRI, which showed disc herniation in the lower right side of her back. All of the doctors agreed that she was essentially unable to continue as an officer. We filed for a disability retirement and went to trial on that. Both experts believed that she was unable to continue in her occupation with permanent work restrictions. The disagreement was really what caused the disability. The matter was heard, and the hearing officer found that we were not able to show that it was caused by her work injuries, and so he found that it was caused by getting up off of the couch. And we believe that she's basically punished for her good behavior and following the doctor's recommendations and not treating more actively and being a squeaky wheel.
Thank you, Mr. Eatman. Okay, let's turn this over. Since this matter was not moved forward to consent at yesterday's disability meeting, today we have a couple of options, and I just want to explain those options before we open it up for discussion. The first option, of course, is the board can move to vote and accept the recommendation of the hearing officer, and the outcome of the vote will be what we have. The second option after our discussion is that we can reject this, and that would put the board into the position where we would have to become the hearing officer, and we would have to review all the evidence and have further discussion at the January meeting, and that would require a motion for me to take. But before we choose either of option A or B, I want to open it up to discussion and questions from the members and the board. So, anyone want to start?
I have a question for Johnny Tran. Are these truly the only two options, either to deny or reject as opposed to defer?
Hi, Karina. Thank you for asking the question. There's different iterations of what Charlie said. So there are other options, and I sent you those options in an email yesterday. But you can do other things, like you can ask additional information from the committee, from staff. You can refer the matter back to the hearing officer to explore different questions you may have. So there's other actions that you deem appropriate. I think what Charlie was saying is definitely correct and gets to the point of what happens if this board is interested in not accepting the hearing officer's recommendation. Well, now you're left in a situation where you have only a summary of information, not all the facts before you. And so the board has written in rules to protect your decision and would invite you then to look at all the evidence to make that decision later. So yes, to answer your question, Karina, you've got a plethora of different options. To answer your question?
All right. Yes, no, thank you. And I have pulled forward the various options. So I'm free to share those, I presume. But we could first adopt the committee's findings and recommendation, request additional information from the committee or staff, reject the committee's findings or recommendation and adopt an alternative decision, refer the matter back to the committee or the hearing officer with questions or instructions for further proceedings, or take whatever other action is deemed appropriate.
Charlie, this is Paul. I've got a question. If we pull this back into the board for decision, is the core decision that we're going to be making oriented around whether this injury occurred as a work-related injury or other type of injury?
Oh, is that question directed to me?
Yeah, that'd be fine, Johnny. If you could answer, that'd be great.
Sure. The hearing officer determined that Officer Minton is disabled and can't continue the work. Mm-hmm. And so the real question at issue is whether or not she qualifies for an industrial injury, that is, that the predominant cause of the injury, of the disability, was work, or if she should continue to receive only her non-industrial disability retirement, which she's currently receiving.
Johnny, we have a number of new members, and I think it would be really helpful at this juncture if you could just take a step back and explain the hearing officer's role, why we go to a hearing officer, what is the value and benefit to SDCERS of doing so. If you could just provide a little bit of context, especially for new members, I think that would be very much appreciated.
Great, thank you for the invitation. So board members, the city's retirement plan lays out specific elements that are necessary in order for you to award an industrial disability retirement. The factors include, is the member permanently incapacitated? Is that the result of an industrial injury? Is the retirement rendered necessary because of that incapacity? And did that incapacity arise out of a pre-existing or mental nervous condition? The only issue in this case is whether or not the incapacity for Ms. Minton was caused by her work injury, or was it caused by her non-work injury? The injury on the books, according to the hearing officers, is stepping off the curb, I believe. And then the injury for the non-industrial injury was getting up off the couch and then collapsing after that. So for the longest time, this board has referred these cases to a hearing officer, a retired judge in this case, because they often lie on issues of fact and medical testimony, stuff that most of us are not experts on weighing and deciding. And so we retain Superior Court retired judges to help with that analysis, given that that's been their expertise for 20 plus years, is to hear evidence, hear expert medical testimony, and then the hearing officer gives you, the board, a recommendation. That recommendation is generally followed because they are your experts in helping you make a decision, but of course it is your ultimate decision whether to follow that recommendation or not. Karina, does that answer your question?
It does, thank you. And I think that provides some context. Is that Bobby that would like to speak?
Yeah. What is it about this particular application of Officer Minton that caused the committee not to either approve it or move it to the consent? Because in past history, they have certainly denied other disability retirement applications. So what was it about this one that caused them not to go forward?
Charlie, I think that's a question better answered by you than.
I can speak to that. One of the issues in our discussion is there seems to be an inconsistency in the ruling that if she has a serious injury stepping off the curb, was treated, and then another period of time lapses, I believe it was 5 years, and then suddenly when she gets off the couch to feed her dog, she collapses and has another injury. To many members on the committee, myself included, it seemed that those injuries were in fact related, which was a decision that the trier of fact in this case thought was independent. So that's what raised some doubts in my mind, and I believe in other people's minds.
I would also like to ask a question. I understand the attorney described the first injury being on December 15th of 2011. Is there any connection then between that initial injury and the stepping off of the curb in May of 2012?
Madam Chair, this is Susan Youngflesh from staff on behalf of SDCERS. If I can address the board in regard to your question. So, and I'd also like to, if I may, have the opportunity to kind of discuss the standards. I know Johnny had talked about it a little bit, but I wanted to go into it a little bit more because I think that would provide clarity. But to immediately address your question, the 12-15-11 injury, she injured her cervical spine. This application is based off her lumbar spine, so it was not connected. She did treat for both of those things, the 2011 injury, and that had resolved later, as well as the 2012 injury, which also later resolved. But before I go into the facts, if I may, which I think would clarify some of these things, if you would provide me the opportunity, may I please discuss some of the standards as far as industrial disability retirement? Okay, thank you. So I know Johnny talked a little bit about what happens and why this ends up at hearing. I wanted to point out a few things to sort of lay the groundwork, specifically that in these cases are different than member appeals because member appeals, the board directs to hearing. However, in these cases, we do an internal review after the member applies for industrial disability retirement or any disability retirement. And they provide us with all the documentation necessary. Then it goes internally to Sandra Clausen, who is our medical review officer. If there is a material dispute in the evidence, then under our board rules, it is then sent to legal and sent to hearing. If there's no material dispute in the evidence, then she makes a recommendation to the board to grant or deny the disability retirement. As you heard in this case, Ms. Minton is on a non-industrial disability retirement right now, which the board approved. So as you're aware of, the only issue here is causation. So Johnny had brought up under the municipal code that the 4 elements that she has to show is that she's permanently incapacitated from the performance of duty, that arose out of the course of her employment, which is what we're discussing, renders her retirement necessary, and is not based off a pre-existing nervous or mental disorder. Now, the concept here about causation and whether it arose is whether the substantial cause, as is defined in our board rules, of the permanent incapacity is due to a work-related injury. So it's not just a nexus or a, as been stated in case law, infinitesimal or inconsequential amount. It must be a real and measurable connection between the employee's disability and his employment. And again, that's in a case law, which I'm happy to cite, but I don't think it's necessary unless you want to know the citation for that. The other thing that I think it's important to understand in this case is that workers' compensation, which oftentimes the records come into play in disability because they treat for workers' compensation case, is not the same as the standards for disability retirement. And so a member may be awarded disability, or not disability, a workers' compensation award, and might be determined disabled for workers' compensation, but that does not bind the board to determine that their disability, that they should be entitled to a disability retirement. That's really important to understand because a lot of those words overlap between the two. So in this case specifically, this went to hearing in May in front of the Honorable Judge Herbert Hoffman. You heard from counsel who represented Ms. Minton at the hearing. The applicant called Dr. Thompson as a witness, and SDCERS called Dr. Tayab. So these hearings act as a trial of sorts, or a mini trial, I like to say, because you have the same sort of rules that come into play as far as having an opening, having a brief, having testimony, the ability to cross-examine witnesses, having a closing, and admitting evidence. So in this case, there was approximately 100 exhibits that the hearing officer reviewed and took into evidence, and the case itself took about 6.5 hours. So the hearing officer, Judge Hoffman, recommended that the board deny the industrial disability retirement of Officer Minton. And Judge Hoffman heard from both Dr. Thompson and Dr. Tayab, but based on the evidence and specifically the lack of any medical evidence for those 5 years between 2012 and 2017, he found that the injury was non-industrial and not connected by a substantial amount, which is the standard substantial cause, to the 2012 incident. After that, the opposing counsel moved for reconsideration, and the hearing officer, and then we objected to that. The hearing officer reviewed everything again and addressed the underlying basis for the motion for reconsideration, which was cumulative trauma. And there was a considerable amount of testimony about cumulative trauma at hearing, which I'm happy to share with you if needed. And again, reiterated that he believed this should be denied. So again, Ms. Minton's already receiving a non-industrial disability benefit. The difference is that there'll be a different calculation should she be approved for an industrial disability retirement. So at this point, I see that Ms. Calera has her hand up, and I certainly don't want to ignore that. So
yeah, I'm sorry, and I apologize that I'm looking over the information as well. Natasha, please go ahead.
Thank you, and thank you, Susan. I think that's really helpful. And just to answer Bobby's question, why the committee, has some concerns, and I just wanted to share a little bit more about my perspective as well. And I had been on a disability committee prior, so I was on disability for about 4 years, and I have always supported the process and have never really deviated from that. But I had a concern about this one, and I think when I read that the doctor thought there might be some cumulative damage, that was, that just, sort of made me stop and pause a little bit. Had she had an MRI, which the doctors didn't order one, that might have shown disc damage, that would have resulted in having more medical verification. When I read that there was a flare-up, to me that a flare-up means that maybe there was something pre-existing and it flared up. And then the one fall causing such permanent damage, so I understand, there was discussion on cumulative, and I don't necessarily want to go to the point of becoming a hearing officer, but I think it might be helpful to read and understand more about the cumulative damage, and also to understand more about that one fall and how that actually could result in permanent damage. And I don't, again, not necessarily wanting to go through or put them through or Officer Minton through that process. I would like to understand it a little bit better to feel more confident in upholding the decision. And I certainly respect the process, but that's, just to answer the question of where I was on the item.
Thank you so much, Natasha. That's very helpful. And Lou Maggi also has his hand up.
Thank you, Karina. Thank you. My question is about something I read in the materials. Let me find it here in my notes. It said something about Ms. Minton being bound by the account of her injury in a minor injury report a while back, and the judge made a comment that he felt that was a little bit unreasonable. I'm just curious, what is our staff's position on that? How much are people bound to those documents, and what is our view on cumulative back injuries as you guys are reviewing these claims?
Thank you. So I'll address both questions first because the fact question takes a little bit longer. I'll address Mr. Maggie's question. So I read that as well, and she certainly wasn't bound to the account of her injury in that cumulative trauma was not the basis of her application, and that was dealt into in detail within the hearing. And so the hearing officer takes into account anything in regards to that body part. They are bound to the body part that they applied for. So say, for example, if you applied for your foot and then you show up at hearing and say, oh, I want to add on my hand, at that point, the hearing process would start all over, and we would sort of kick that back to Sandra to have them reapply on their hand and provide documentation because, say, one body part they're able to qualify for a disability retirement on without going to hearing, then what's the point in going to hearing per se? And so, no, we bring in all documentation, all evidence they want to provide for the specific body part going to hearing or body parts. It is their burden, though, to bring in any evidence that the applicant would like, although SDCERS often provides the majority of the medical records in these cases as evidence. Does that answer your question?
The first one, yes. And then regarding cumulative?
Okay, so I think that also goes into what Ms. Blaira was addressing. And I'm glad you asked that because I went back through the transcript and I have a few excerpts that I want to sort of read to you from the testimony of Dr. Tayab that I think might be helpful to you. So when we're exploring cumulative trauma and being questioned on that at the hearing, Dr. Tayab testified that the 2017 injury was a separate injury not related to 2012. So just to lay the groundwork as to what the questions were. So on May 30th, 2012, she injured her back or about that time, stepped off a curb, but she went back to full duty on June 8th, so a week to two later. She saw a chiropractor for about 2 months and was deemed permanent and stationary on August 3rd, 2012 with a 0% impairment rating. So again, those are workers' compensation terms, but it does still kind of show what the chiropractor at least looked at her for. In the transcript, Dr. Tayab testified, quote, I think her injury in 2012 can be best described as a minor injury. And the reason I say that, and this is very important, is that so minor that no x-rays were ordered, no MRI was ordered. She got better essentially after 2 sessions of chiropractic care. So in my mind, I don't see how this injury contributed at all to what she experienced in 2017. And then going into the facts a little bit more, we asked Dr. Tayab in regards to cumulative trauma, and this came up yesterday at the Disability Committee, what would you look at for cumulative trauma? And he said, there's usually a more kind of a quote unquote paper trail. There's more treatments ongoing for a long period of time. So he says, testifies, but if you're claiming a cumulative trauma, then I would expect that there is evidence in medical records of doctor's visits, treatments, not just a patient saying I had some pain, which is, again, I take her at face value, but she was obviously able to work full duty. So if we look at the timeline in this case, and this isn't the testimony, but just going through the medical records. So she has this 2011 injury where she's in altercation, and that's for her cervical spine, and she's treated. Again, she's here for her lumbar spine. She was deemed permanent and stationary on November 5th, 2012 for the 2011 altercation. The Dr. Ignacio said, quote, I find no rateable impairment for the injury she sustained, and she's returned to full duty. The next injury, which is the curb, where she stepped off a curb, was on May 26, 2012, where she then returned to full duty on June 8, 2012, received about 2 months of chiropractic treatment, was deemed permanent and stationary on August 3rd, by Dr. Head with a 0% impairment of the whole person and, quote, unrestricted and has returned to her full duty job responsibilities as a police officer for the city of San Diego. In 2015, she moves to the wellness unit without any sort of restriction. She's not required to wear any sort of duty belt in the wellness unit, as you probably know. She's not having any medical treatment for that entire period of time until this incident in March of 2017, where she, in her words, her back gave out. And as she testified in the transcript, she was trying to get up because her dog was barking. Her back gave out. She fell to the floor. It was not a minor incident. She laid there for over half an hour, at which point, because her dog kept barking at her because he wanted to be fed, she rolled over and had to push herself up off of the coffee table or table that was there to get to her feet, and was then able to stand up. So it was not a minor incident. And it wasn't until after that when MRIs and x-rays were then ordered. So from that injury is when she then later received the duty belt restriction. It wasn't prior to that. And so what the doctors have to look at and what is the objective versus the subjective evidence. And there is no objective evidence that the 2012 injury is related to the 2017 injury. The 2012 injury was minor enough that no MRIs were ordered, no x-rays were ordered, and she was determined to be resolved after 2 months of chiropractic treatment. So that's what Dr. Tayeb based his opinion off of. Now, juxtaposed to Dr. Thompson, who then based his opinion off of just his own experience and said, I just haven't seen something like this, essentially. And that's all within the transcript, which if the board decides they want to review everything, is there as well.
Susan, it sounds like you're quoting Dr. Tayeb extensively, but really summarizing Dr. Thompson's position in this. From my perspective, I think probably we should review the entire transcripts just to get a fair assessment of everything. And a quick question, you talk about the transfer to the wellness unit. Was that discussed at length in this hearing?
It was, the wellness unit was. And the only reason I summarized Dr. Thompson is that he didn't provide a lot. So Dr. Thompson did testify, but he testified that the 2017 injury was an exacerbation of the 2012 injury. So it's exact kind of opposite of what Dr. Tayeb said. But he said he couldn't believe that it would be based on the 2017 injury because he hadn't seen anything like it in his experience. And so because he didn't delve into anything else, that's the only reason I'm summarizing as opposed to quoting. There's just not a whole lot I can quote.
Okay, and did Ms. Minton point to a reason why she went to the wellness unit, left patrol, and took the desk job?
And this is based off my recollection, but my understanding was in part because of the 2011 altercation, which I don't know if you're familiar with, because I understand it was quite extensive, that because she was able to rehabilitate herself, she was looked at as a good fit to, and I'm paraphrasing again, so this isn't from what the testimony is, but that she was sort of like a role model to others based on the 2011 injuries. Does that make sense?
It does. Did she talk at all about specifically wanting to leave patrol because of the gun belt or anything of that nature?
If she wanted to leave patrol because of the gun belt, not to my recollection, but I would have to review the transcript further for that question, which I'm happy to do, and I can right now if you'd like.
That's okay. Thank you.
I have several people in the queue. I'm going to recognize Roberta Spoon right now. Bobby, go ahead.
You know, I don't know how much time, Karina, we are going to spend on this, but I have several questions about it. I would like to read the transcript. I'd like to read what Dr. Thompson had to say. And two things I'd like answered right now is, number one, did she receive workers' comp?
She did apply for workers' compensation, but as far as I know, at least any sort of award wasn't provided as evidence.
So we just don't know?
I do not know. I will say, though, because she had a 0% impairment rating for at least 2 of the injuries, I'm not sure what the status would be at this point.
Okay. And then Marcel, can you tell us the difference, the financial impact of an industrial disability and a non-industrial?
Good morning. Yes, I can. So a non-industrial disability is 1/3 of the final average salary for a member. An industrial disability is at least 50% of the final average salary. And the reason I say at least 50% is because if you have already retired or if you are eligible to retire and your retirement benefit would be more than 50% of your final average salary, you do receive that. But the industrial piece of it is 50% of your final average salary. The second piece of that is a non-industrial disability benefit does not have any preferred tax treatment. An industrial disability retirement, that first 50% is treated as tax-free income.
Thank you.
I saw, Johnny, you had your hand up and then it went down. I didn't know if you still had something you wanted to add on.
Thank you, Karina. I just wanted to make clear, since there are a few new board members with us today, of the different roles at play here. So you're acting as the judge in awarding the benefit or not, and I am acting in my role as your counsel. So I am, in a sense, the judge's attorney, and any advice that you want or procedurally or how this process should work should be asked to me. Susan is similar to Joseph Heathman in that she is representing an adversarial process. This is American jurisprudence, and we believe that the best way to get to the facts or the truth is to allow 2 parties to present evidence of such. So when Susan is discussing facts, she is doing so in an adversarial, advocating way. And so I do want to just recognize Susan's role in this, as well as Mr. Heathman's role as well.
Thank you, Johnny. Is Harvey Lederman on today?
He is not.
He is not. So fiduciary counsel is not here. I am going to side with Bobby here. I think we've spent a lot of time on this item. I don't think that this board is ready right now to take action. I think there is several questions out, as Natasha referred to. And so we can try to summarize that direction to staff, but that would be generally where I am right now. I really would like to defer this item if possible, and if that's not an option, to start drafting very specific questions of what we'd like follow-up on.
Here, Karina, you've got Brett's hand raised, and Bobby, I don't know if you want to answer that before you do it, but what we would ask, if you're not making a decision now but would like to look at the transcript, we can have a board member propose to table this until January, and in the meantime, staff would give you the hearing transcript as well as the medical evidence and other evidence received at the hearing. And then you come back to the board.
Yeah, and I'm going to go ahead and recognize, I think it's Roberta Bobby Spoon again.
Just from a process standpoint, will this be a decision that is made by the entire board? Will the entire board be reviewing documents, or will there be an ad hoc committee appointed? Question.
Yes, Bobby, it's set up so the entire board would receive the evidence. And the reason for that is what you have is only a summary of the evidence by a hearing officer that is recommending that you deny the benefit. So if the board is interested in not following that, we want to provide you with the evidence to support any decision and an alternative that supports your decision and is fair for the record.
And Brett, I know you've been patiently waiting, so thank you.
Sure. I'm sympathetic to the officer, and I'm more inclined to defer to the opinion and the decision of the prior fact. I mean, a retired municipal judge heard all of the evidence. It's his job over the course of a long period of time to discern truth and consider evidence intelligently based on the law. And so, despite my personal sympathies, having suffered lower back pain myself, I'm inclined to trust the recommendation of the hearing officer. And I'm willing to read the transcript if that's what the group decides to do, but I don't do that for a living. He did his entire career, and I would make a motion to accept the hearing officer's recommendation personally at this point.
I appreciate that, Brett. I think also that it is a dangerous precedent for us to sort of become that acting hearing officer. It will take us away from other fiduciary duties as well. So I definitely get your point. I don't think that we are really in the position to take on that role, and that's why we go through this process of having the hearing officer for exactly all the years of experience and diligence to review the materials. Anyone else would like to chime in? I'm not hearing either a move on this item from you, Brett. What I am hearing is a willingness to look at the transcript, and
Karina,
it sounds like defer. Go ahead, Brett.
We have Lisa Marie Harris with her hand up.
Oh, thank you. Lisa Marie, please.
Yes, good morning again, everyone. I would echo Brett's comments. I'm sympathetic to the issue, but I don't feel comfortable just receiving the transcripts. I'd want to hear some testimony as well. I don't think just reading a lengthy document is really going to be helpful for me. So if there is additional review by this board, I would ask that there's much more of a process included other than just reviewing the transcript.
This juncture, I would like to make a move to set up an ad hoc committee to review the pertinent information in this case prior to the January board meeting, and then revisit this item at the January board meeting. If there's no objection to that, I would like to appoint 3 members to serve on an ad hoc committee. I will respectfully request if Natasha, with all of her years of experience, and Charlie, and then perhaps another board member or 2, if you would like, that could also serve on that ad hoc committee.
I'd be willing to do that, Karina. And is that in lieu of all of us getting the transcripts, or would we all still review that and have the ad hoc committee?
I think we would all have the information, but then appoint a committee to go over this and then have another discussion at the January meeting. And I just wanted to, before I voluntold people, I just want to check with both Charlie and Natasha that they would be open to that idea. And if there's any other discussion from other board members, then I would like to make that motion to appoint an ad hoc committee.
Karina, I'd be happy to serve.
Thank you, Charlie. Okay, great. Okay. Natasha, does anybody else want to serve on the ad hoc committee to review this matter? Hearing none.
I would like to, Karina.
I'm sorry?
This is Lou. I would like to.
Lou Maggi, Natasha Kalara, Charlie Hogquist. Yes. So the motion is on the table.
I'll second it.
Okay, thank you. And then we'll just look to call the roll.
I'm sorry, who did the second, please?
I'm sorry, it was Bobby Spoon.
Thank you, Bobby. Okay. Okay, we're ready to vote. Karina Coleman?
Yes.
Brett Bartolotta?
Yes.
Michelle Bush?
Yes.
Natasha Kalura?
Yes.
Lisa Marie Harris?
Yes.
Charlie Hogquist? Charlie Hogquist?
is an aye.
Thank you.
Aye.
Paul Kaufman?
Yes.
Paul Lotz?
Yes.
Lou Maggi?
Yes.
Louis Nguyen?
Yes.
Cliff Shearson?
Yes.
And Bobby Spoon?
Yes.
Okay, great. Bobby, you still have your hand up. I didn't know if that was intentional or anything else to discuss. No. Okay. Great. So that motion passes unanimously. Charlie, did you have anything else to add from the Disability Committee update?
The only update was we are moving well along in processing our disability applications. And again, I want to take a moment to thank staff for doing a good job and serving our members. And that will end our Disability Committee report.
Very good. Thank you, everyone. I'm going to now recognize Bobby Spoon as the chair of our Business and Governance Committee. So, Bobby, I'll hand it over to you.
All right. Well, the B&G committee met yesterday, and the committee approved all of the action items by unanimous vote. And before I review all the action items and make a motion for the consent agenda approval, I understand that we may have a public comment speaker. Melanie?
Yes, Mr. Lasaga is present.
Then I am going to pull action item number 4 from the consent agenda, and may we hear from Mr. Lasaga?
Hello?
Hi.
Okay.
We hear you. Please
All right.
go ahead.
Okay, to the members of the board, as I mentioned to the members of the committee, in going on drop, the MEA union did not inform me of a possible substantial pay raise for the engineers. This was a big crime of omission. The union wards did, for the other divisions, did inform other employees. Why did you keep me from this information as MEA staff? That's what I'd like to know. And my union ward had messed up my project and was totally out of the loop. So I go to the MEA staff. You represent me. You give me that information, unless you have some reason to discriminate against me and not tell me. Every one of Michael Zucchette's employees is white. Managers and officers are white. That's who I was dealing with. They usually think I'm a lower level Hispanic employee. And if I talk about their ineffectuality with professional management, they think you're attacking them. So they have a motivation to screw you by not giving you the information. And now SDCERS say, oh, our hands are tied, the rules. Well, the city of San Diego disobeyed the rules. I had a senior in June 2020 who knew everything about these things, who told us there would be no more pay raises for engineers, except for those who signed the plans, because the registered engineers had already had a substantial raise. If the issue I'm talking about was made public, it would be that the public would be told that registered engineers who passed a multiple choice open book exam have just received over several years and a few more years, a 75% pay raise. That is what the union didn't want to tell me about. And yet there is a rule. That senior of mine retired in June. You're not supposed to put in somebody who is not of that level for more than a month. In February, when I was going on drop, I still had an out-of-class assignment employee who had no clue, who had no information, just like the management of my department, who didn't give me any of that information. So they broke the rules. The city broke the rules. Oh, but you are all about rules so that you can have unanimous votes on every action. The city of San Diego, the county of San Diego.
a great cul-de-sac. Well, this is something that then you acknowledge. My case is like a case that police employees had, and you weren't gonna do anything about it. Your hands were tied. So the policeman had to go to court. The court forced you to do what you said you could not do. But you don't want to learn your lesson. You want to punish me and make me go to court as well. Think about that. You're making me go to court because you don't want to change the power structure of the city of San Diego. That's basically what my issue is. You are mistreating me because you talk about rules, but the rules were broken for me. The MEA did not represent me. The city did not give me a senior like they were supposed to do by the rules. Everyone else can break the rules, but I don't get to have any say.
Thank you, Mr. Lasaga. The time has expired. Appreciate your coming in person, talking with us about your case.
Thank you, Mr. Lasaga. Thank you for your comments, Mr. Lasaga. The B&G committee heard from Mr. Lasaga yesterday at our meeting, and at this point, I'd like Marcel to give us some background into the reason why staff recommended that we deny his appeal.
Thank you, Bobby. In this case, the rules that govern us are the municipal code, and the municipal code is our plan document for City of San Diego members. The municipal code is very clear, and I'm going to read you a quote from it. Before a member may participate in drop, he or she must voluntarily and irrevocably designate a participation period of 60 consecutive months or less, elect to receive either the maximum benefit or one of the retirement settlement options described in Division 6, designate his or her beneficiary for the continuous payable bond upon his or her death, stop accruing benefits under any other division of this article, and then it goes on to what happens when they're actually in drop. But the most important piece of that is that once you begin your participation in drop, you have made that voluntary and irrevocable election to participate in drop. Mr. Lasaga's drop period began on February 6th of 2021. So he has been participating in drop for a number of months, and the municipal code does not allow us to rescind his drop period. That is different than some of the other things that we talk about, which are board rules that the board establishes, but this is actually in the municipal code. And I know that Mr. Lasaga referenced a time when we did allow people to exit drop, and we talked about that yesterday at committee, and I would like to clarify a little bit. That was the purchase of service litigation that was, I believe, about 11 years of litigation between the city and SDCERS that talked about mispricing contracts, and part of that litigation, the litigation was not litigation where people were asking to get out of drop. The litigation was the city suing SDCERS over the pricing of contracts. Part of the resolution of that involved a small number of members being allowed to rescind their drop election because we had to reprice contracts. So it was a very different situation. I'm happy to answer any other questions about the process and what SDCERS has available to them at the time someone enters drop.
Are there any questions of Marcel from the board? The committee yesterday unanimously adopted staff's recommendation to deny the appeal of Mr. Lasaga. We didn't feel that we had any flexibility because it is written in the municipal code. There are other employees that have entered drop that entered drop prior to the announcement of the system-wide pay increases that occurred in this year. So there are other people that have experienced the same issue of entering drop, where the drop amount is based upon their salary at prior to the pay increases. However, the primary reason is that it is in the municipal code, and we really don't have the ability to waive that. So at this point, I move staff's recommendation to deny the appeal of Mr. Lasaga. Ms. Hazard, will you please call the vote?
Yes. Karina Coleman?
Yes.
Brett Bartolotta?
Yes.
Michelle Bush?
Yes.
Natasha Kalura?
Yes.
Lisa Marie Harris?
Yes.
Charlie Hogquist?
Aye.
Paul Kaufman?
Yes.
Paul Lotz?
Yes.
Lou Maggi?
Yes.
Louis Nguyen?
Yes.
Cliff Shearson?
Yes.
Bobby Spoon?
Yes.
Okay, motion passes 12-0.
Okay, great. At this juncture, I would like to suggest a 5-minute bio break before we go into the investment committee review. So please come back here at 10:10. Thank you.
I'm correct that we have to vote on the consent items still for B&G, and then we can move to investments.
That is correct.
Thank you, Greg.
We will.
And Bobby, this is Lou. I was just hoping we could speak on item number 3 for a moment before we vote on those.
That's fine.
Thank you.
Is Ted on the call? Greg?
Hi, Bobby. This is Michelle. I do not see Ted in attendance.
Okay.
Bobby?
Yeah.
Ted is on via VPN, but I am prepared to answer any questions that you may have on item 3.
That's fine. I have the numbers if that's Lou's question.
I have the numbers and I have the supporting information on the indices, so I can answer questions.
Thank you.
Sure.
Okay. So waiting for a couple folks to come back. Okay, I think we're all filing in here. So for this next portion, we're going to review the investment committee. I'm going to hand it over to Cliff Shearson, our newest chair.
Karina, we still need to vote on the consent agenda for the B&G.
Then I'm way ahead of myself. All right.
I defer to my good colleague, Roberta Spoon.
I'm so sorry, Bobby. I would not have taken the break had I known, had I realized that. Go ahead, Bobby.
That's all right. Don't worry about it. There are 12 items on the consent agenda, and Lou has a question or would like to discuss number 3. And number 3 is the staff's recommendation to approve the 2022 drop interest crediting and the drop annuity rates. I can tell you that the committee unanimously adopted both. The staff reported that the interest rate to be credited to member drop accounts will decrease from 1% to 0.8%, and the drop annuity rate will remain unchanged at 2.1%. Do you have any other questions on that, Lou?
I do, and thank you, Bobby. My question is, are those monies held separately in some sort of cash type account, or are they blended with the rest of the trust?
So, Lou, thank you for asking the question, but all of the monies are commingled within the trust.
Okay, and so I guess my overall question is, and I understand the drop is designed to be cost neutral or as close to it as possible. The question is, if our fund did close to 25% last year, and we're lowering what we're paying folks on that money below 1%, there's quite a bit of a disparity there. And I understand it's tied to different indices because it's shorter term deposits. I get that. I just wonder if the indices we're using are still the appropriate indices, and when the last time we looked at that was?
2009.
Okay. Would it be appropriate to, I mean, economies change over time, and it seems like that's quite a spread there. Would it be appropriate to make a motion to look at the indices we're using and determine if they are still appropriate?
We could, if it's the board's desire to have the B&G committee to review that board rule, which includes those indices. Yes, we could do that.
Okay.
That sounds like a motion to me.
I think you can, if there's no other objections from the board, you can provide direction to staff, and we can put that on the agenda. Or if the board wants to go a little bit more formal and make that a motion, we can do either way.
I think we can just direct staff to come back to us, at a later committee date with a review of those indices as discussed.
Okay, be glad to do that.
And one final question: the difference between what's being paid out and the rate that we actually received on the money, does that just go to offset other costs associated with drop, or it just stays with the trust overall?
It stays with the trust overall. Probably getting more into the discussion, probably it's going to happen at the committee, is that your interest period is 5 years. And so back in 2009, the committee and the board believed that having an indices that was a 5-year period to match the up to 5-year drop period was appropriate. And they looked at, what should that be invested in? And that is more of a short-term period. They decided to go with more of a short-term bond indice and cash indice as opposed to a illiquid indice. So that's kind of how we got to where we are, and the same with the annuity rate, which is a 20-year period, which is also uses a 20-year indice average. Again, looking more at corporate bonds and U.S. Treasuries due to the liquidity of the payouts. But we can talk more about that at the committee.
Thank you.
All right, are there any other questions from the board on any of the other items that are on the consent agenda? I'm not going to go through all of them. The material was included in your board packet, but I'm happy to answer any questions that anyone has. Okay, hearing none, I would like to make the motion to move the consent agenda. Please call for the vote, Ms. Hazard.
Sure. First, if I may ask a question, are we pulling item number 3? Am I changing the motion to remove that item?
No, 3 is on, in the consent agenda.
Okay. Okay, Ms. Spoon, you did the first. Is that correct?
I made the motion.
Thank
you.
Okay. All right, and I will call the roll. Karina Coleman?
Just a moment. I just want to be sure because it looks like we have consent 1 through, it says to approve consent 1 through 3 and 5 through 13.
It's 1 through 13 with the exception of 4. We pulled 4.
I see.
That we've already voted on. So it's 1 through 13 with the exception of 4.
Okay, and I think the mover was Bobby Spoon on this one.
Right.
Okay, we're ready?
So we're calling for the vote.
Okay. Karina Coleman?
Yes.
Brett Bartolotta?
Yes.
Michelle Bush?
Yes.
Natasha Kalura? Natasha Kalura?
Yeah.
Thank you. Lisa Marie Harris?
Yes.
Charlie Hogquist?
Aye.
Paul Kaufman?
Yes.
Paul Lutz?
Yes.
Lou Maji?
Yes.
Louis Wynn?
Yes.
Cliff Shearson?
Yes.
And Bobby Spoon?
Yes.
Okay, motion passes 12-0.
Okay, great. Now we can move forward. My apologies again, Bobby. I'm going to now turn it over to Cliff Shearson to review the investment committee materials.
Thank you very much. The investment committee met yesterday afternoon, and we had 3 action items. The first was a recommendation to adopt our resolution to continue to be able to meet in the manner that we're meeting today. And that we had a discussion with Johnny Tran. The second was the selection of a real estate consultant. It was a discussion led by Jamie Hamrick, and we had presentations by the incumbent real estate consulting firm Townsend, which is part of Aon Hewitt, and another firm called the Makita Investment Group. And the third was an action item to approve the Stepstone Private Market Program Policy and Investment Plan. Stepstone obviously working with us alongside of Grosvenor. The bulk of the meeting was spent in interviewing the 2 finalists out of the search for a real estate consultant to SDCERS. And after hearing both firms present their cases and their qualifications, we had a discussion, and there was a motion which passed unanimously to select Makita Investment Group as the real estate consultant for the firm. In addition, there was a motion which also passed unanimously to approve the Stepstone Program Policy and Investment Plan. I would move that all of these be approved by the board.
Okay, great. Thank you, Cliff. Any discussion from other board members on these items? I know we have a couple of investment committee members on the board as well.
Let me just say that while I'm new in this responsibility, I've been involved in other investment groups, and I want to thank all of my colleagues on the investment committee. It's sometimes challenging when we're at our homes and not in the same room with the people, but I thought we had a really very, very robust and very professional conversation with both the firms, as well as a really first-rate outline and background presentation by Jamie Hemrick.
Yes, and I'll just echo that sentiment. Staff definitely presented two very qualified consultants for the committee's consideration, and yeah, definitely appreciate the effort that went into that search. Okay, so I do not think we need a second on these. We do need to call the roll if there's no further discussion by anyone.
Okay, ready to vote? Okay, Karina Coleman?
Yes.
Brett Bartolotta?
Yes.
Michelle Bush?
Yes.
Natasha Kalura?
Yes.
Lisa Marie Harris?
Yes.
Charlie Hogquist?
Aye.
Paul Kaufman?
Yes.
Paul Lotz?
Yes.
Lou Maji?
Yes.
Louis Nguyen?
Yes.
Cliff Shearson?
Yes.
And Bobby Spoon?
Yes.
Okay, motion passes 12-0.
All right, great. Then I think we are going to be asking Greg for his comments and any other comments from trustees and staff, but I know Greg has a few words to share with us at this point.
Yes, I always do, I seem to. So thank you. I'll make this as brief as possible, but I wanted to give the board a quick update on our active member election to replace Sarah Mayen's vacancy. As you know, Sarah has left the City of San Diego employment to become the City of Chula Vista's finance director, and as such, she was required to vacate her seat. Upon learning of Sarah leaving, staff immediately began the election process to seek her replacement. And a nomination notice was sent to active city employees for nominations. And we had 2 nominations. So we will be having an election. The first person that submitted their name was Tom Battaglia. Many of you know Tom. He was previously a SDCERS board member, and he would like to rejoin the board. And our other person that was nominated is a former SDCERS employee. She was the Deputy Chief Investment Officer for a number of years, Dawn Clark. And so we will be holding an election in December, and hopefully by mid to late December, we will have a certified election, and staff will be working on our orientation to get them to the board in time, sworn in for our January 13th and 14th meeting dates. And we discussed a little bit already about transitioning to open meetings, so I won't belabor that. But again, we are hoping to have open meetings in person in 2022, and it's just a matter of when that is actually going to happen, but it will happen. So we look forward to that. I also wanted to recognize and welcome our executive assistant, Rosie Anich. Although Rosie's been here only for a short period of time, quite a few board members have had the opportunity to interact with Rosie. So we are very pleased to have her on the team, and she has big shoes to fill with Cynthia Joyner. And so we're just pleased that Rosie's been doing well in learning a new role responsibilities, and just appreciate Rosie for that. And I'd also like to thank Melody Hazard for the past 2 meetings as serving as our board support. And so thank you so much, Melody. You've been doing a very wonderful job and being patient as we've worked through these technological issues at this meeting. Rosie will be taking over, being first seat, as they say, starting with our audit committee meeting coming up, and then our board meetings in January. So transition is coming along nicely. Thank you. I also wanted to give you a quick update on SDCERS staffing in relation to the City of San Diego's vaccination rules. Although SDCERS is an independent independent of the City of San Diego, we are a independent department and we follow the city personnel rules. And we're also, much of our staff is included in a labor agreement between the city and one of its labor unions. And the city has mandated COVID vaccinations for all employees by December 1st. And non-vaccinated employees who are not eligible for medical or religious belief exemptions will be subject to discipline leading to termination. So I'm very pleased that our entire management team has self-reported as vaccinated, but we do have about 5 employees who have self-reported being non-vaccinated. Now, while this 90% vaccination rate is above our 80% community rate, these five people will have a decision to make of whether to become vaccinated or hopefully receive a medical or religious belief exemption. And I hope everything works out because I like all my team members and I want to keep working with them. So hopefully if they don't get vaccinated and they need an exemption, hopefully we can accommodate them through mask wearing and social distancing per the city rules. A quick update for Prop B. Same as last meeting. The city and its unions are still looking to see what do we do during phase 2, how do we bring those 3,800 people back into the system. Marcel has been doing a tremendous job in working with Chiron in supporting the city and the recognized employee organizations as they continue their negotiations to find a path forward. I believe we're starting to get to common ground and coming up with solutions, but we're not there yet. But it will happen at some time during 2022. And we are, Marcel's been doing a good job with her internal team, making sure that we're ready to support the decisions that are made. I would like to give a quick couple staff recognitions. I'd like to recognize Johnny Tran and Susan Youngflesh for being co-instructors at a CalPERS course in Retirement Disability Administration. I'd like to recognize and thank Ted LaSalvia for serving as the chair for the CalPERS Finance Group Roundtable. I would like to recognize and thank Marcel Voorhees-Rossman, Cynthia Queen, and Liza Krisafi, as the 4 of us were featured speakers at the Retired Employee Association's October meeting. I wanted to share that former SDCERS board member Joe Flynn emailed us to say, that was a wonderful fact-filled presentation at REA today. Professional, polished, network quality. So thank you, Joe Flynn, for that nice shout out. The Retired Fire and Police Association held their annual luncheon in person at the Bali High in October, and I was fortunate to be asked to attend and provide a brief SDCERS update. And I have to share with you, it was really enjoyable to see so many of our members in person, especially Charlie Hogquist, who saved me a seat for lunch in a very, very well-attended room. And finally, I would like to highlight the Mesa Water District invited me to provide an abbreviated version of the lessons learned from a pension crisis presentation. And my October 26th presentation to their board was well received and sparked some very interesting board governance discussion. And this concludes my remarks, President, and thank you very much for the opportunity.
Thank you, Greg. At this point, I just wanted to also give kudos to the staff for all the hard work that's been accomplished this year as we're heading into the end of the year. It's another tremendous COVID year and I'm sure demands on the HR perspective. So certainly appreciate all the effort that goes on behind the scenes. Any other comments from board members or
Lisa Marie Harris has her hand up.
Yes, thank you, Greg. So a couple of questions. So is the goal to have us meet in person at the January meeting, or that's still to be determined?
That is still to be determined. I don't anticipate our community is going to fully open up. My hope is maybe for a hybrid approach, but we really want to assess that in late December, early January, so we have time to prepare people to let them know where the meeting's going to be held, how to properly notice the meeting so that the public understands how they, through transparency, how they can interact with the meeting. So more information to come in late December, early January.
And then if and when we do meet, will we all have to wear masks the whole time during the meeting?
Again, we will be assessing the City of San Diego rules and the local public health official. I can say hopefully not, but we will see. My goal is to keep everybody safe and to have everybody feel comfortable in the meeting so that we can have some very robust deliberations and people feel comfortable in the environment that they're in.
Thank you.
All right. Any other comments? As otherwise, we're going to be heading into closed session. Okay. I'm not hearing any. If you are not part of closed session, please disconnect from the Zoom meeting at this time. Thank you.
No, when we come back, when everybody's back. Everybody's not back yet. We're not muted, are we? Okay. Yes. Okay. Okay, we're ready to proceed if you are.
Okay, great. We're back from a closed session. Johnny, do you have anything to report out?
There's nothing to report out, Karina. Thank you.
Okay, that does bring us to the end of today's agenda. Don't believe there are any other issues or business. So at this point, we are going to adjourn the meeting, and thank you everyone for attending today.
Thank you, Karina.
Thank you.
Thank you, and great job, Karina.
Bye-bye.
Thank you, everyone.